So when somebody passes away, they have stuff. They have brokerage accounts, they have bank accounts, they have real estate, they have automobiles. It has to go to the beneficiary. And probate is the process by which the court allows the navigation of the assets over to the beneficiaries. Well, there's two misconceptions that I've come across. One is going to take forever to get it done, and the other is that it's extremely costly. It's going to cost millions of dollars to do a probate. So in the will, the person who passed away nominates or appoints a personal representative. In some states, it's an executor. That person is the person who typically starts the probate. The key steps are filing the will with the court and the death certificate. Then the paperwork is prepared and filed with the court. The personal representative is appointed. The personal representative advises all the beneficiaries of the will. They start gathering up the assets of the estate. They gather up who the creditors are. Then after all that stuff is done, notifying the creditors, notifying everybody. After all that is over, they can start liquidating the estate. In my experience, it's 6 to 8 months. One of the big chunks of time, so to speak, there's publication in the newspaper, and creditors have got 3 months to file claims against the estate. Other delays are administrative delays. For instance, filing paperwork with the court. That can take some time. Getting court orders can take some time. So there is built-in delays in the process. The other main type is a summary administration, and that is usually if somebody is deceased more than 2 years or if the estate is smaller in value, under $75,000. There's no executor appointed and there's no publication in the newspaper. It applies if the person has assets that's just in his or her name. So what happens there, instead of the will guiding as to who gets the assets, state law guides. So you have to look at your family tree and see under the law who are the beneficiaries of the estate. The downside is some assets may be going to someone who the deceased person didn't want to go to. Revocable trusts are a probate avoiding mechanism, it does work, but the downside to it is if you don't do what's called funding the trust. So in other words, if you have a bank account with somebody and you don't notify them that there is a trust, when you pass away, that asset's gonna have to go through probate. And that happens all the time. The other problem that I've seen is that after someone dies, nobody could find the trust. Mom or dad did a trust, they passed away, nobody could find it. And that's a big problem. If you're trying to sell a piece of real estate, the title company is not going to allow a closing if they don't know who the right seller is. Well, if they owe money and they don't have assets, then I would say there's really nothing to do. But if they have a big estate and there's creditors, you might want to start the estate. Every situation is different. Or you can wait 2 years, because after 2 years, creditors can't file claims against the estate. Well, those are two different questions. If they live in different states and they get along, then there's not a problem. With FedEx and emails, that's not a problem. If they don't get along, then that can be a problem. So for instance, if there's a piece of real estate that the 4 adult beneficiaries now own, and one of the beneficiaries doesn't want to sell it, you're going to end up in litigation. Couple of things, make a list of all your assets, where your bank accounts are, where all your stuff is, and give it to your most trusted person. The other thing you can do is you have a situation where you have kids that you love and trust, add them on the bank accounts as beneficiaries. For real estate, you can do something that's very popular now, an enhanced life estate deed, where you put your children on the deed. They don't take title until after you die. It doesn't affect your homestead exemption. It's become very, very popular. The Ladybird deed.